Morning, everybody. Thank you. Welcome. And yeah, good that you have joined us. Some breaking news this morning. Thank you very much for letting us know who was that told us he was on first this morning. Thank you, Nicholas. Appreciated. So there it is. Quick update then on where we are with the Public Procurement Bill, folk. And then we've really pleased that we've got Prof Geo Quinot that's joined us today, as well as Advocate Helen to just take us through some initial thoughts and comments on the bill and what the NCOP might consider. And think of this as being possibly the first inputs that you could have to make submissions then to NCOP as per the screen that you could see up right now. Just a quick update. So National Treasury put out the Public Procurement Bill, a draft of that. It was formally tabled in Parliament in June 2023. There was a lot of discussion and debate. There were formal public hearings that happened to the Finance Subcommittee on the bill. Those took place, and there were public hearings on that. There were many submissions that were made as well to the subcommittee. And at the end of the public hearings and in the closing comments, the chair of the subcommittee then I think it's probably right to say unofficially sent the bill back to National Treasury with all the comments and said, please address these comments that you've just had and come back to us. National Treasury did that. I think it was September sometime they went back. No, it was actually later than that. Went back to the subcommittee with an update, suggested update to the bill, and reported then at the first update that they had not had enough time to go through all the submissions. I think they said they had only gone through about 80% of the submissions, which I think probably was about 50% of the comments. And Treasury clearly understanding the subcommittee clearly understanding the implications of that, asked Treasury to go through the rest and come back the next week. And I think on the Thursday, they were sent an update. I don't think there was much of an update that they received the next day. And on the Friday, they considered the update from Treasury. There was an opportunity for those that had participated in the public hearings to give some more comment. And the very next Tuesday and Wednesday, the Portfolio Committee did a clause-by-clause review. They updated the bill, and fairly soon after that, they made a submission to the National Assembly. There was a debate at the National Assembly, and it was passed at that point in time and then forwarded to the NCOP. And you see now where it stands. Prof, please add any corrections to what I've just stated.
No, absolutely correct. Perhaps just one or two quick comments about what is curious about what we've seen in the National Assembly. So what is somewhat curious about what we've seen up to now is that there's very little indication in the National Assembly process, in the committee, Portfolio Committee, Standing Committee process, to suggest that the committee itself considered those comments. And that's notable because remember, when a bill is tabled by a sponsoring minister and hence his department, in this case, National Treasury, that's it. They hand it over to Parliament, and then Parliament drives everything from there forward. So Parliament calls for comments, and we comment to Parliament. and what is a little bit odd and concerning in the Standing Committee National Assembly process is that, as Shaun has indicated, when they received all those comments, the initial set and then the follow-up comments as well, every time they sent National Treasury back to go through the comments and ostensibly tell them what to do. And that's very concerning. I mean, it's one thing to say to the department, look, you know, we've received these comments, please let us have the benefit of your views on these comments as well, and then we consider everything. But it's quite clear that that's not what happened. They basically outsourced, you know, excuse the pun, that key function to the sponsoring department. Now, of course, the sponsoring department has got a very particular view, especially on those comments which are very critical. So I think that is something that is very concerning. And then, of course, the other element that I think one must just point out is that if one watched all the proceedings before the committee and then before the assembly as well, it's quite clear that there was only really attention to that one dimension, to the preferential dimension. Everything else was largely ignored. And I mean, I've gone through all the comments that were submitted, detailed comments on many other aspects under the bill. And those were, I mean, there's no indication that the committee or the assembly paid any attention to any of the other aspects. And I think that's highly concerning. And then subject to what happens now in the NCOP, and I'm very pleased to see that they've now also called for input, and anything that might subsequently happen should this be referred back to the assembly, I think there's a very good chance that this particular bill up to this stage has not met the constitutional obligation of participation, and it makes it, of course, then vulnerable to an attack, a challenge in the courts purely on parliamentary procedural process, nothing to do with the merits or the substance of the bill, and that would be a real shame, because it would mean that we've put a lot of effort and time into the substance, and then the thing gets chucked out on the basis that's got nothing to do with the substance. So I think it's a difficult position where we're in, but we do now, very importantly, have this further opportunity, and I think it's a very important one.
Is there any limitation to the stakeholders that can now submit comments through NCOP? I mean, is it only limited to provincial stakeholders? No. Is it anyone can now do that?
Anyone, and this is what I think is significant about this news that Nicholas has just shared with us, that it is now really anyone again, which is not necessarily a requirement, right? Parliament as a whole must facilitate public participation, not necessarily every committee at every stage. And in many bills, we see that when it goes to the NCOP, the National Council of Provinces, they do not, again, ask for complete open public consultation. They would only get input via the provincial delegations, and provinces may or may not engage within the province. So this is significant, and it also suggests that anyone can comment. But I think one should also be mindful of where we are in the process. The NCOP's function is to bring the provincial and to a lesser extent municipal perspectives to the national lawmaking process. And I think, when one comments and when one engages now in this opportunity, one would be well advised to frame whatever comments you have within that mandate, because those are the things that the NCOP is constitutionally obliged to really consider. And I think it's unlikely that they will really go very deep into something that's got absolutely no provincial or local government implication. But having said that, of course, in this bill in particular, it's difficult to draw that line, right? Because everything that's regulated here will inevitably directly impact on provincial, and then very, very specifically local. We know that local is the one that's going to be most impacted. And local is also supposed to be kind of represented, in a sense, that voice. It's meant to be represented via the NCOP.
There are at least 4 different parties online today that have made submissions to the National Assembly process. Just scanning now. What's stopping them just resubmitting those things that have not been considered?
Nothing. No, absolutely nothing. One can simply just put it in again, although one must be strategic about it, right?
Yeah.
Because I think it is, given the time constraints we're dealing with here, I think it's highly likely that we're going to see a repeat of what we saw before the standing committee. The select committee is going to ask Treasury. And you know, I think a perfectly a sensible response by Treasury on submissions that simply just, you know, dropped again would be to say, look, this is exactly the same submission that was made to the standing committee. We did engage with it there. And of course, that would quite fundamentally undermine the weight of your submission. So what I would suggest, and what I'm certainly going to do in terms of the two sets of submissions that I'm responsible for, is I'm going to go through those again. I'm going to look at which have been addressed and how they've been addressed in the revisions to the bill as passed on the 6th of December by the Assembly, and then adjust those. But I will also add a or at least highlight the provincial and local government lens on my own submissions.
Interesting. I hope all of those who are online are thinking about those submissions, because I also noted that there were, I think Western Cape Provincial Treasury made a submission to the National Assembly.
Yeah.
And there were one or two municipal representatives as well. I think, in fact, it's, yeah, there's at least 5 different groups now, just having a quick look here. 5 at least online to this. So maybe, you know, putting it in the context of why is this important for the province, and this has not been addressed previously, might give it some more weight. Interesting. Prof, let's just quickly kick off, and if we can just ask you to and you can share. It might be easier for you to share, Prof, the actual bill. I can do it from this side. I do have it open. But maybe just take us, given that this is a provincial focus, and maybe just a couple of points of interest around the role of provincial treasuries, and then also, yeah, just, I mean, let's start there.
Okay, so I've shared my screen.
Thank you. We can see that. Yes.
You can see the bill. Okay, great.
We can. Yeah.
I was worried that I'm going to share the wrong screen. Okay, so I mean, I think that there are a number of issues from a provincial/local perspective that one should really bring to the attention of the NCOP. To me, the biggest issue remains one that we've raised before the National Assembly as well, but I think must be raised here again with a slightly different focus, and that is the very, very significant extent to which this bill simply just delegates the real lawmaking power to the minister. Now, if we think of that from a provincial local perspective, I think it is very important to note that there's a significant rulemaking centralization in that move at the national level, and that comes at the cost of provincial and certainly local engagements. And I think especially for the larger locals, that's a very significant shift. Metros, that it will be a very, very different environment for them. So, you know, if I'm a senior finance exec in a metro or an MMC for finance in a metro, that would certainly concern me, and I would want to engage with that and ask, look, you know, is this very, very open-ended nature of regulatory power that we're now granting the National Minister of Finance appropriate in this context, given that this is meant to be within our cooperative governance framework, meant to be something that we share across the levels. So I think that for me remains a major issue. And there, I think, you know, there are things that one can point to that are particularly problematic, procurement methods, criteria for awarding tenders. Those are the kinds of things that I think are better suited for a lower level of government, for the detail at least. As is well known, I've always advocated having the framework in the bill itself. That is still something that I would put to the NCOP. I think that is the way to actually balance within your cooperative governance your framework. Put the basic framework in the bill, and then allow flexibility and freedom downstream in terms of the actual implementation. And that means really downstream, right? Allowing a PT, for example, to set whatever is appropriate in that province in collaboration with its own departments, allowing a municipality to have some control over the kind of methods that's appropriate for its context and the kind of criteria that's appropriate for its context. So that's, I think that remains for me a major issue. And I think there's, from a cooperative governance, there's a major issue. So, you know, the issue around differentiation to me remains significant. While we've been repeatedly told that, yes, there are these one-liners sprinkled through the bill that says, no, we can, you know, we could do this. It's still the national that can. And to me, that remains problematic. I mean, I think one must ask that question. To what extent is a national treasury sitting in Tshwane really, really able to judge the conditions on the ground in, let's say, rural Eastern Cape? Is, for example, the PT not much better able to make that judgment call to say, this is the appropriate thing for our context? So for me, that remains something that I would want to see much stronger in the bill. And then I think directly linked to that is the issue around, sorry, I forgot to scroll down here. Let me just pull up the
Section 6.
For me, then, directly linked to that is this whole Public Procurement Office with its powers and functions. I remain absolutely convinced that it's complete overkill. And as I've said many times, I don't say that simply just as a way of criticizing National Treasury in the current CPO. I also say that in their defense, in support of them, because I just don't think it's viable to put all of this on a single body that must now do everything. So again, there I would want to see the role of provincial treasuries being strengthened vis-a-vis the PPO. So if you read the bill at the moment, the powers of, if you look there at sections 4, 5, and 6, also then the rest, 7, 8, you must read against that framework. You will see that the default really is, it's the PPO. And then whatever is kind of left over or below that, PTs can do. I'm not convinced that that's the best way to go about it. Of course, one can say, look, but the bill provides for PTs to do whatever, and it's only in cases where the PPO wants to step in. And that's good if you've got a very benevolent PPO that's got a light touch, and, you know, but the thing is, we don't know, right? We've got no guarantee that that's going to be the case. It might be the complete opposite. And unfortunately, the reality is that we've had a fairly heavy-handed regulator of sorts up till now, with instructions and things that are, you know, make procurement more challenging than it should be, to put it mildly. So I would want to, for example, see more powers going to PTs. I worry about this thing that both a PT and the PPO can issue binding instructions. I worry about the fact that different PTs can issue different instructions from a supplier point of view. That to me is problematic. So if you're a big construction firm, civil engineering firm, you're doing big work up and down the country, now you may be faced with very different rules between different provinces. And it's not clear to me how we are going to deal with that, for example, even when it's at the same level of government, right? So it might be that a PT issues an instruction to their municipalities, which may be very different from what happens in the province next door. And I think, again, for local government, that's going to create significant challenges. I'm not sure it's delivering on one of the key objectives of this bill, which is to bring alignment, coherence, to do away with this fragmentation. I don't think that's happening here. So you know, it's really back to that main question of cooperative governance. You know, chapter 3 of our constitution, which I think is probably one of the most neglected chapters, and which is in fact a very, very important chapter. Our understanding of how different levels are meant to work together. And I just don't see that reflected in this bill, and that's something that I will say very loudly to the NCOP, because I think that's their main role. Where's the cooperative governance? And one can take that same, you know, concern to the tribunal, I think the tribunal is, in principle, a good idea. I like the tribunal. I think it'll be better to go to the tribunal rather than to courts. But there's a major question that many people's raised and that's just been flatly ignored. And that is this not going to be a tremendous bottleneck in the system? Should we not think about a tribunal? Should we not devolve this tribunal system to, for example, provincial level? KZN has shown us that it can work provincially. Yeah, trumping provision in 3.4 remains problematic for me, especially around the MFMA. I think one must look at that. There's an identical provision in the MFMA. My best attempts to convey the difficulty of two trumping provisions that says exactly the same and that will inevitably play in the same space has been completely lost up till now. I will repeat that to the NCOP because I think it's irresponsible for a parliament to make two laws that says the same thing and then they clash directly. I mean, I don't want to be that CFO in the municipality that's faced with rules now coming out under the Procurement Act and the MFMA, and they're not fully aligned. And then they've both got trumping provisions telling you, no, follow this one. I'm curious to see what the AG will do with that. And then perhaps the final point I'll make is, and I think, again, very, very important from a provincial perspective, this very significant centralization of e-procurement and the e-systems. It's explicitly stated in the bill. I think it's now section 30 and 31. Just scroll up a bit. And again, you know, just this is not a normative statement, it's a descriptive statement. We know as a matter of fact that some of our provinces have run quite a bit further with e-procurement than nationals ever been able to do. So now that power is effectively taken away from them. They're told, look, you know, at some point you will have to do away with your system and join ours. And let's just say that, unfortunately, our attempts at national procurement e-systems have not been a beacon of success. And again, I'm not throwing stones here. I think it is pretty much a matter of resources. I don't think those officers are appropriately resourced. And we all know if you don't capacitate, you know, an office like that, how on earth do you think are they going to be able to deliver? And I don't see more capacity being committed behind this. So that's something that worries me.
Thanks, Prof. Helen, do you want to just jump in and maybe add some perspectives, and then we'll ask those who are online to come in. Prof Geo hasn't spoken yet on chapter 4, and that might be something you want to just quickly raise as well, the preferential procurement chapter.
Thanks, Shaun. Maybe just a little bit of the cynical side of myself, and I would rather ask Prof to comment on it maybe at a later stage. But going now to the NCOP process, understanding this is an election year, what teeth will they really have to counter decisions made on a parliamentary level already? You understand the master situation. So I'm just, you know, yeah, I'm just a little bit cynical about the process. From my perspective, maybe just, and Shaun has flighted it now on the preferential procurement, what is very from this newer version and the version that I've seen in December is that they've deleted the section about the preference point system. So again, now we're going to have a framework without a preference point system. So we don't know how it's going to work. The version we've seen talked about 10 to 40 points for preference. And now it's been deleted. And I don't understand why. I couldn't see anywhere where it was discussed why it should be deleted. And I think what I would like to draw the attention to is if you read the wording in chapter 4, it's very interesting that if you go to section 2172 of the Constitution, it says nothing prevents an organ of state from implementing a preferential procurement policy, which according to me talks the language of a discretionary mandate. But if you go into the wording of the procurement bill, we see things like a procurement institution must set aside and must do subcontracting if feasible and must do pre-qualification. And again, for set-asides, pre-qualification, subcontracting arrangements, all of those would be will still need to be prescribed. So we still need to get the prescribed conditions. We still need to get the thresholds. We still need to see the formulas. So it's just very interesting to see the wording and maybe just draw everyone's attention also back to the fact that local content is back on the drawing board. Although I know I'm the cynical one, but actually, the local content section for me is a very good section compared to the previous provisions, that there will be a more scientific approach before local content is made an instruction to be used. So I'm not that negative about the section, but we just need to be aware that it's back. And then I've also seen certain words being used in Chapter 4 that's not been defined. Words like advanced sustainable development, which I don't understand what that is, and measures for beneficiation and innovation, which again has not been defined. So I think that's just a bit of a caution when we see these things, that we just need to understand what the content entails. So the whole preferential procurement regime is going to change, and we need to be aware of it from a procuring institution. To add to Prof's concern as well is I think they forgot about municipalities and local government. If you read the MFMA, for instance, it's very clear on the role of provincial treasuries vis-a-vis their mandates towards local government. But here, provincial treasuries may make binding instructions, and it appears that they may make it on municipal level. There's also not a clear distinction about how do we work with delegated municipalities that report to provinces and those not delegated reporting to national. So how are we going to distinguish between that? Because it may appear now that municipalities may have two masters. What's also interesting for me is we know that this district development model is a presidential focus, and I can really see the benefits from a economies of scale and a procurement perspective applying a district development model, but I don't see it in this bill. So that's just also something that I would like to highlight. Looking at the tribunal, so you guys can immediately see what's my pet projects. On the tribunal, agree with Prof. I think it's going to be a bottleneck. If I look at the wording that's being used, it's more in the nature of arbitration, not that much of mediation, because there's words like subpoenas, and lawyers being involved. So I think we're just looking at a mini court. So this most probably will be similar to a labor court process. And my biggest concern then would be Section 55, that then indicates that during the period of the tribunal process, there's a standstill. So contracts might not be concluded. And looking specifically from a local government perspective, working with grant funding, if there's a standstill, there may be a situation where local governments won't be able to spend their money. I think that's just my few cents, Shaun, mostly planting seeds for you guys to consider and look at.
Thank you. Thank you. Any response there, Prof, on what Helen said up front around the power or the influence?
Yeah, I mean, I've had this conversation with a number of people, and I think, of course, as politics go, it's unlikely that, under normal circumstances, unlikely that the NCOP will, I think, reject it. I think that's highly unlikely. But I think the other thing that we need to really bear in mind is the dynamics around the timeframes that we're in at the moment. And it's important here to remind everyone that in our system, a bill cannot be transferred from one parliament to the next, meaning across elections. When Parliament rises, with other words, its term stops and we're going into an election, that's it. All business before that Parliament comes to an end, it's done. If it's not been passed, it just automatically lapses. And the newly constituted Parliament after that election will have to start from scratch. Now, this means that we are in current conditions under tremendous time constraints simply to get this thing through. And with through, we mean all the way to the president's signature, right? That must happen. So I think, you know, one possible scenario that I do see here is that if the NCOP comes back and says, look, we don't like this, that, and the other, so we are adopting a version with fundamental changes. Let's take this tribunal system, for example. We say, no, we're not going to go for a national. They put in a new provision, or they completely change one of the provisions to say that this must be at provincial level, and then that's a real substantive change. And then the bill must then go back to the National Assembly, back to the Standing Committee on Finance, and they must go through a process again before the National Assembly can vote. So it's quite a, you know, it's quite a lengthy process. And given where we're at in terms of timing, the result of that may simply be that this thing just doesn't make it, that they run out of time. And that in itself, I think, is a possibility. And now whether that's a good or bad thing depends on your views. I myself tend to change my view 3 times every day on that, depending on, I think what we've got at the moment is so disastrous that it's probably better just to have this and start working with it and try and panel beat it, or whether, no, we cannot make that mistake. We need to get a, I don't know, you know, beauty's in the eye of the beholders, who knows. Just 1 or 2 quick comments on what Helen has said. Let me start at the bottom end, this 55 that I've pulled up here. I think, you know, what's really important is to note how narrow that 55.2 is in terms of the scenarios where you would be able to proceed despite a standstill. And I think that's something we need to very carefully think about. I mean, emergencies, of course, I think that's a no-brainer. But I don't think emergency would be the only kind of condition under which it would be justifiable to proceed with the procurement rather than allow the standstill. And here, I think we're back to both cooperative governance, but also to just understanding where procurement fits into the broader administrative function. You know, we know that there are things like budget timelines, etc., etc. So a simple standstill, it may seem so simple, but it may result in the project coming to an end because the budget cycle will run out. Then you just can't spend the money anymore, or whatever. You know, there are many other conditionalities that may play in on why in a given case the standstill should not automatically apply. And what I fear is that this reference to emergency here would be stretched beyond all recognition, and that we are going to go into these silly fights with the AG and in courts and in the tribunal. Was this really an emergency? Who determines whether it's an emergency? What is an emergency? And we know what's going to happen. Then there's going to be an instruction. Then we're going to fight about who's got the power to issue the instruction. And I think that's just unnecessary. That's the kind of thing, you know, that we shouldn't, after the bill, have to fight about. So I would want us to really think about this again. And with this, I think there's also a broader concern around both deviations on the one hand and exceptions, or whatever you want to call it, on the other hand. And we, despite many of us having raised this now on many platforms, there's still not clarity on that. So when we're talking about a deviation at the moment, we talk about a particular way of doing procurement. Is that really an exception, an exemption from law? Who knows? I take the view it's not. because our law allows for deviation. So when you're within the rules of deviations, you're following the law. You're not being exempted from the law. This bill seems to take a slightly different view. So there's a lot of uncertainty there. And again, we know that there's a major bottleneck. And then I fully agree with Helen on chapter 4. There are so many questions there. Many of us take the view that we're not sure this can be called a framework, as 2173 really requires. Telling the minister to do whatever basically is not a framework. I'm not sure that is appropriate, and I've highlighted. Sorry, I think I've scrolled over. Where's the numbers? They've jumbled up the numbers.
That's first. Keep going. Chapter 4.
Okay, so I've highlighted there also something. I mean, Helen made this very important point about, there we go, about undefined terms, and we know from painful experience how important these things are. And to me, the most problematic one amongst many in this chapter is that complementary goals, and you find it in all these sections.
Mm.
So those of you that kept a close eye on the parliamentary process would have remembered that there was this big fight around price. I was completely misquoted, and the honourable Manye, is a member of this standing committee. I don't think he heard exactly what I said. And there was a whole thing about price, and it was just such a silly debate, because I think the idea that you can take price out of adjudication is just mad. The question is not whether price should be there or not. That's the wrong question. It must be. The question is really, in addition to price, what do we look at? That's the real question. And now they've fudged it with this complementary goals thing. What is that?
Yeah.
What I'm talking about here? Maybe functionality? I don't know. So I think it's dangerous to start using undefined terms like that. My preference would have been for them to say, if they didn't want to put it in the bill, which I could live with, because I do think if we put a very narrow ambit for criteria into the bill, you run into potential difficulties. I would have then preferred to say, and such other criteria as prescribed. Just make it clear what we're talking about. Then we don't have a fight about what is the meaning of complementary goals. When is something complementary? When is something a goal? We can't even agree at the moment on preference under the 22 regs. We can't agree on whether BE certificates is a instrument or a goal in itself. We've got a fundamental disagreement in our system about it, and it's got far-reaching implications for everyone. And that's just on the term. So I think we're again setting ourselves up for that same kind of drama if we use this kind of loose language. And I would certainly be commenting on that as well, to say, look, let's just do away with this.
Two bigger questions, just to put to you, and then we'll open up the group for some comments. I'm thinking of a municipality that will now have two authorities, CIDB and Public Procurement. And when they have to, at their local level, fix a waste treatment plant or do some work in infrastructure, they're going to have now, which they have not had before, detailed methods coming from the National Treasury, and they'll have the CIDB. Will that be an issue at a local government level? Is that something they will be able to manage fairly easily? Question. The other one, and let me just quickly put this last one to you, Prof. The other one is, I don't see anywhere the provincial parliamentary, the legislatures, will they still have to be governed by their own FMPLA, I think it is, Financial Management for Provincial Parliaments and Provincial Legislatures. I don't think that's covered here. And is this NCOP the time to ask that question? Any thoughts, Prof, and then we can open up to the group.
Yeah, let me quickly just respond to the second one first. I just want to scroll down to the coverage section, which I'm also a bit disappointed about, but that's more self-serving. I would have liked them to include, here we go, include universities in there so that we just get some clarity about that, but they've opted not to do so. Yeah, it's quite strange, because if you look at 3.2, it's only very particular provisions or parts of the bill that's now being applied to legislatures. Also very strangely, just provincial and national, not local, right? So again, quite a strange position. And if I were to be a local government politician, one of the things I would immediately ask is, okay, so why not us? Why do you think that your powers are so much more important than ours? Because we are also elected legislatures. Remember, that's the basis of our system. A council is an elected legislature. So I think there are certainly questions, and I think you're right. This is absolutely the point to raise it. It is a very similar point to that trumping one I referred earlier around the MFMA, because in that special, I mean, the parliament version of the PFMA, if you like, they've also got that. So how these powers are going to align, but there's a lot of alignment that's not been thought through. I mean, so if you think about the MFMA, so they repeal the whole of Chapter 11 of the MFMA that deals with procurement. But when you read through the rest of the MFMA, there are numerous references to SEM policy, to things like that. That's just not touched. Now, what are we then going to do? For example, the capital, just go and read the capital asset regulations and provisions in the MFMA. There's direct reference to your SEM policy. Now, we're not clear how, so there's lots of alignment issues, and this is the right place to raise that. On your first point about the CIDB and construction, is absolutely, and I think, you know, it potentially makes the situation that we're in at the moment even more difficult. I think our learned friends at local government level is going to start to feel the pain of provincial government and national. That's been under this dual regime now for a while, under the, I always forget, is it now a framework for whatever, or is it now a standard, whatever the latest terminology is, for infrastructure, whatever, issued under the PFMA, that's binding, sitting alongside the whole CIDB thing. Of course, local government has been able to escape that, rightly so, because there's no such power under the MFMA, but all of that changes with this bill, right? And if the current thinking in National Treasury, now, of course, under the PPO, is that we are going to continue to issue fairly detailed rules or standards in the infrastructure space. Now, under this bill, then the entire ecosystem is going to be subject to this alignment issue. There is the very slight revision of the CIDB Act in this bill that suggests that the CIDB, when it wants to make rules, can only do so in agreement. But again, you know, it's one of those things, as I've said earlier, it's all good and well to say, okay, well, you know, don't worry about it, these people will figure it out. Well, that's if you've got a very well-functioning, benevolent, you know, collaborative CIDB and PPO, but the reality has not been that. So what's going to be the reality on the ground? I prefer to have that rather set out in the bill itself. Just tell me, how's this going to work? And the last thing I'll say about that is, you know, a big concern is the very broad definition of this act in the bill. If you look at that definition, it includes basically anything that can be issued. Now, the effect of that is that it makes all of that binding, and it brings it all in under the trumping provision. So that would mean that even a standard issued by the PPO under the procurement bill will, courtesy of the trumping provision in the Procurement Act, trump anything else and everything else, which leaves you in a very difficult position, even for, you know, seasoned lawyers. That's a really difficult thing to figure out. You know, if you've got something in a, let's say we've got something in a regulation issued under the CIDB Act, and now you get an instruction or a note. I see they've even got notes now that's been issued by the PPO, Which one of those two take preference? That's not an easy question to answer, you know, and again, it forces us into litigation to answer operational questions, which is inappropriate. So I think that's something we have to really think about again.
Thanks, Prof. Anyone want to comment? We'd love to hear from you, your thoughts. We see we've got a number of people from different provinces, Western Cape. There are some national public entities that are with us. I see Ron has raised his hand. He'd love to say something. Anyone else would like to? We'd love to hear from you. Go ahead, Ron.
Thanks, and thank you to Prof Geo, Helen, and Shaun for your outstanding contributions. Very informative, and I think it is news that we're not limited to just we're not limited by having to be a provincial stakeholder. We can still comment generally. I think that's a huge opportunity and breakthrough. I just want to make a brief comment and then just ask Prof Geo in particular for what are our instruments we have available. So just as I've been listening to the discussion about a local level and a municipal level, what I've realized is that the obligations that are placed on an SCM, let's call it a procurement official because they don't use SCM, are in fact of a very high standard. So, we're accustomed to procurement, people doing procurement, maybe some disposals, but by introducing a broader scope, such as asset management and contract management, when I don't believe is the capacity at a junior level to perform that. So remember the salary scales and the grades that exist at a local level to appoint a procurement practitioner. You're not expecting all of these abilities and roles and responsibilities to be part of that. I don't think we have the capacity in the country. We're asking here for people who are specialists not only in procurement and disposals and transformation, but now a specialist in asset management and a specialist in contract management to take responsibility. Thank you for picking that up. I see they've also included risk management, which is badly praised, but you can include logistics, etc. So in order to have the senior SCM practitioner at a local level, I don't think you're going to find these people within the budgets. Normally these are specialities that are distributed across a municipality or a local or a provincial level. But to have it in one office, which is what which one anticipates it. Because remember, the moment you say a procurement system, it becomes the role of the procurement people. If my assumption is incorrect and my logical leap in connecting the dots is incorrect, please correct me. Then on the trumping clauses, correct me if I'm wrong, but I think there's a third trumping clause, and that's the PFMA. The PFMA also has a trumping clause. Now, my very limited understanding of trumping clauses is there can only be one. You can't have two or three. So how on earth you can have a PFMA trumping clause, a procurement bill trumping clause, and an MFMA trumping clause? I don't understand. In fact, I would argue it is unconstitutional having a trumping clause at a national level. And I just bear with me. I read an article in this last week about, I think Western Cape government are challenging something, or somebody else, but they're making use of an act I didn't know existed, the 2002 Act about what occurs when you sue certain organs of state, and it says you've got to give them 6 months notice, etc. But what was interesting in the preamble, and Prof, I think you're going to love this. In the preamble, it says that the previous act on penalties and whatever these things are, was in the paradigm of a constitutional republic. They didn't use the word republic, but some other words. But the key issue is that this has now changed because South Africa's become a democratic, a constitutional democracy, and it was a democratic that comes in. So for me, if I just take a purely theoretical perspective, bearing in mind that a lot of the theory from democracy comes from subsidiarization, from the Roman Catholics' view that was, I think, a papal decree in 1937 or so, is it's a bottom-up approach. So in a democratic constitution, my argument would be that, in fact, any trumping that exists actually occurs from the bottom up, not from the top down. And I know that goes contrary to, sort of international trends on centralization, nationalization, all the rest of it. But I believe there is an issue there. Now, in order to phrase the question, I need to provide context. And Prof, I heard you say something about this being a disaster, and I don't want to say that I'm interpreting that this bill as it is a disaster, maybe or maybe not, you didn't intend it. But what I do want to say is that our view as the National Research Foundation has been expressed publicly by our acting CEO at a public platform at our international conference. We regard this, and I forget the words our acting CEO used there, but they were, at minimum saying that this bill is a step backwards, that we as an NRF do not support it and have major concerns. And just for interested parties, and Shaun, you did refer to our contribution, we weren't one of the largest contributors. We were the largest contributor by far. And I say that not as a boast, we weren't expecting to, but if you take all the submissions, there were 2,300 line items. At the NRF, we submitted 300 of those. No other entity came close to that number. So we've looked at this very carefully and have drawn in the best experts around the country and the continent. And our considered view is that this will not take the country forward. In fact, our view is that we take it backwards. Because we believe the thinking has been superficial. We believe there has been inadequate benchmarking with more developed jurisdictions, as well as inadequate benchmarking with developing jurisdictions. And we've given examples of where they, for example, on standstill periods and roles of who's responsible for contract management. We believe other countries such as Kenya are far superior.
Okay.
The question then is, and Prof, it may be a difficult question, and it's not a politically correct question, but from where the NRF sits, that if it does nothing else, it would like to delay this. In fact, it would love to delay it until after the election so it can start again, so that we get something that everybody is feeling very happy about and constructive about. Our view is very pessimistic, and we see it as getting worse. So this is just the tip of the iceberg. So Prof, we want to take a hard line. And we regard you as the SCM legal expert on the continent, at minimum here in South Africa. So when you say, for example, this doesn't meet the minimum threshold for consultation, and you raise other concerns which are, I think, substantive, it then begs the question in terms of an activist role, and this is the question, is what is the most powerful tool we can now adopt to delay the implementation of something we believe is not in the country's best interest? For example, And this is probably a bad example, but it gives you an idea of where the thinking is. Or my superficial thinking is, can we actually, and there are two examples. One is, can we actually make a complaint to the public protector that there is, in fact, an embedded abuse of power taking place here, with the centralization, with these ill-defined powers, with the lack of transparency being in contradiction with the Constitution, and just a cooperative governance, secretary is one example. But the other one, and I take no credit for the insight or for this particular example, it was put in by the EFF in their parliamentary verbal submission. Well, I think they were part of the process. Whether they were a member of the finance committee or not, I'm not sure. But it was a very, very interesting point. They said, and I think it was particularly in the context of Chapter 4, but I'd like to extend it to the whole of this Act. They suggested that we actually needed to go for Constitutional Court clarification on at least one of the key items. And I think there's considerable wisdom in that.
Mm-hmm.
I think it's in our best interests. So, Prof,
Okay.
if we want to take a really hard approach here, because we are waiting for a tsunami that we think is gonna take us backwards. What is the hardest approach we can take to delay?
Thanks, Ron. Go on, let's quickly ask Advocate Nsaluba to come in, and you can give some thought to that in the meantime, Prof. Advocate?
Can you hear me?
Yes, we can. Good morning.
Thank you very much. And I think Ron has actually taken the thunder. However, Prof, I'm going to be a bit precise today and say, firstly, is there a possibility that we can get this version? But secondly, Prof, we know in terms of our mandate that we still have a work to do. Now, my question would be then, what is your thinking around when we meet this year at a conference? What do you see us having as an input? I've heard you talking about separation of powers, but as you were scrolling down, I could see that the shortest route and the easiest route has been taken. I think Ron has a point. We have a legacy here to protect. Either we allow the rush that is imminent in this, or we begin to say NCOP is where the real deliberations take place. We influence at that level, and the influence be such that, one, I keep on saying, one of the interesting things about this presentation is that there is no presentation from the state attorney declaring each clause in terms of its constitutionality. And that is a requirement for any legal instrument for it to move. And I think we need to make a plea for that process. Probably what maybe would be important, Shaun, is again this plea I keep on putting, that maybe we need to invite the chief solicitor for them to assist us with their position in terms of their due diligence that they've done on this legal instrument. We don't wait for someone to do it, but we actually ask the solicitor to be able to provide us with a presentation, because this is a group of specialist experts across all sectors of the economy. So we don't wait for someone to do it. We actually make it the very first step, because it has been glaringly absent, Prof, in all the presentations that have been made. And I've been consistently asking, because that binds the solicitor and the state attorney in terms of declaring through the SACE process that each clause here meets constitutionality, the constitutional requirements.
Okay.
Definitely, Prof. Lastly, the trumping clause one, the interesting neglect on the separation of powers, it becomes problematic because you are talking about a Schedule 4 constitutional responsibility, not a Schedule 1. Hence, I'm really emphasizing that that is the first step that we should do. If we need to make a visit to the solicitor to make sure that this happens, we need to do that. But we need to invite him to make a presentation in this forum of the analysis and the due diligence and then the outcome of that due diligence, clause by clause. Thank you, Shaun.
Thank you. Thank you. Prof and Helen, if you don't mind, I wonder if we should just let the rest just put their points as well. And I mean, we're keen to listen and just get some perspective. So Ingrid, I think you were next.
Yes, thanks everyone, and Happy New Year, even though we are almost in February. So I'm talking today as the Construction Sector Charter Council, and obviously tendering and procurement is very top of mind for all construction companies, and especially in South Africa with a massive rollout of
Can we ask you just to raise your voice? It sounds very valuable, but we can hardly hear you.
Can you hear me now?
Thanks, a bit loud. Thank you, Ingrid.
Okay, so yeah, I'm talking to you as the Construction Charter Council, and obviously for construction and in light of the big rollout of infrastructure projects, tendering and procurement is top of mind. So we wrote as the Construction Charter Council a submission to Treasury on the 12th of September, which wasn't acknowledged and none of the comments were taken into account. But our point is that really what we want is certainty in business, and we need certainty in knowing how to align our companies to best take advantage of tendering processes. So what the Construction Charter Council has been operational since 2003, and we've crafted construction codes that cater for every one of the designated groups that are actually mentioned in the procurement bill, okay? So when we saw the first version of this, we were very concerned about the trumping clause that exists where the procurement bill takes preference over BEE codes. That's another trumping clause that we haven't mentioned here. So what it effectively means is that states and municipal can actually extract certain designated groups in their set-aside or tendering priorities that actually trump having a BEE scorecard. All right, and you know that is very instrumental in corruption in a lot of instances, and it also does not give business certainty in how to align themselves in different provinces and different sectors if they all have this ability to dictate what the set-asides and the preferences will be. So we were very upset to see the trumping clause in the procurement bill taking precedence over the BEE Act, because that renders all the 14 sector councils mute. So that was our biggest problem, and we see it's back in this version that you tabled today, Shaun.
Thanks, thank you, Ingrid. Just to confirm, did you make a submission to National Treasury or to the subcommittee?
Both. We did to both.
Okay, thank you. Let's
Standing Committee on Finance. We also did a presentation to National Treasury. Yeah, so our voice has not been heard, it's not been recognized. And to me, the biggest concern is this trumping clause over BEE. You know, we just want to know, is BEE on, is it off?
Okay, thank you. Let's jump to Chelsea, and then Nicholas, and then Sanele. Hi, Chelsea.
All right. Hi, good morning. Am I audible?
Yes, we can hear you. Good morning.
Awesome. Thank you. So I'm Chelsea. I'm from a nonprofit organization called Plan Act, and our core business is to promote transparency and accountability in local governance. And as part of our work, we've noticed that billions are spent by municipalities in outsourced services. And we've seen the Auditor General's MFMA report, as well as the Staged Capture report calling for transparency, right? So my question is, shouldn't the bill have a legislative framework for transparency to curb corruption and just for, transparency in public finance management? Thank you.
Good one. Thanks, Chelsea. Nicholas, good morning.
Hi, Shaun. Just very quickly, two things that might benefit people. The first, and they're very practical points. The first point, it's just on the NCOP, on the PMG website that we went at the beginning.
Yes.
If you go and find the bill, if you go under bills, you go to procurement bill, you'll find the A list. And the A list is supposed to indicate what changes have been made between the last version and the latest version. So that might help people just focus as well. So just a practical point. And the second point I just wanted to make as well about the process is this is a call, just in case anybody's not clear with it, this is a call from the select committee of the NCOP. That's a committee within the NCOP. But often, or in fact usually, the NCOP also asks the different provinces to run a public participation process in the different provinces by that legislature. And they often have separate calls for comment, different hearings. And I want everybody to please just keep an eye out in case that does happen at your province, wherever you are, and very carefully consider commenting on one and not the other, because yeah, you may want to speak to somebody who can give you legal advice on if that's a good or bad idea in your circumstances. Thanks.
Good one. Thank you. Thank you. Sanele, and then we'll go to Richard.
Thank you, Shaun. Good day, colleagues. Good morning, Prof.
Good morning.
Yeah, mine is not just too much. I was just worried when National Treasury, when they presented it the last time in the National Assembly, they did indicate that if there are any omissions that the Parliament feels that they need to be included, the Parliament must include that as they are seized with the responsibility of drafting the legislation in that sense. And when they said that, it was in relation to some of the comments that were made that they indicated that they didn't read all of them. So I think they went through like 60% or something. And that now, if you look at the current version, it's still, for someone who was commenting on that, you'd still feel that we are not represented in what we have put forward as various groups. And that alone, it puts you in a position where you are unsure whether your comments were read and they were just not considered, or they were not read at all. So you just don't know where you stand. And the issue now is we are living in a political space. Our country is governed by politics. So if you leave this legislation open to bigger interpretation or a large interpretation, you're leaving us in a position where we are vulnerable as procurement practitioners, in a sense that, one, we have a current ruling party now. We are voting in the few coming months. Let's say, for example, they lose power. Someone else comes in, or some political parties come in. This means the interpretation that was understood by the previous regime might be changed by those who would be in power at the time. I'm talking about things that when we made comment, we also highlighted the issues of explicitness in terms of the legislation. When you talk of the threshold, you talk of the positioning of the procurement office, you talk of the establishment of the office of the PPO, and you talk of the fragmentation that comes with the legislation when it comes to delegating some of the responsibilities to the provinces. So those are the things which I do feel that if the bill is left unchallenged at this stage, may create a lot of fragmentation and bottlenecks, and may cause more problem than solutions. Thanks.
Good one. Good one. Thank you. Richard Rapiri, you're still with CIDB. Morning, Richard.
Morning, and morning, colleagues. Yes, unfortunately, I'm still here with the CIDB.
Welcome.
And now, yeah, no, colleagues, I agree with the rest of the colleagues that have spoken before me. We have a serious situation in our hands as a country and as an industry, and affecting other industries. But most of all, in the construction industry, we are in a serious dilemma, colleagues. Our first interaction with the bill, colleagues, was the first draft, which was about 5 years ago. as the CIDB, and we subsequently then seen the bill when what the bill was then, published by Parliament for comment. And in that regard, with that background, colleagues, you understand that the CIDB was not consulted at all by National Treasury, even if we worked with them over the years and years. But yeah, we have seen a relationship breakdown with them, and we are trying to manage that. But be that may, we've made our comments to Parliament as requested, and we have made our views in terms of how this bill should be shaped up. And what we have seen now in this new current bill, even though we have realized that, infrastructure procurement is regulated differently from general goods and services. Yes, some of them that, looks at the mandate of CIDB in the creation, maintenance of fixed assets within the built environment. And if you look at the other side of the Council for the Built Environment, mandated for professions operating in the built environment, and yet all those aspects in the infrastructure delivery chain are within the Minister of Public Works and Infrastructure. Yet there's no mention of the Minister of Public Works and Infrastructure in the bill. So that is a total disregard of the role of the minister. What we have seen is that we have seen a certain clause that says, when it comes to identifying and minister publishing the thresholds, then the relevant ministers should participate in that process, and also those categories. I mean, there's fundamental flaws in terms of how this bill has been crafted. Yet they had a nerve of, introducing the Minister of Trade and Industry within the ambit of that bill, and did not even focus on the main infrastructure delivery process. And we know in the background that within even the National Planning Committee, it was realized that construction industry is key to the National Development Plan. Yet the Minister of Public Works and Infrastructure has been excluded into this bill. So, and when you link that to the National Infrastructure Plan 2050 document, you could see that how infrastructure is a key component in the delivery chain. As the CIDB, we have been over the years putting out regulations, putting out standards, methods that are pro in the delivery chain of the built environment. And we have seen now that there's a total shift that National Treasury will take over that. And yet, also, if one looks at other components like your Zondo Commission recommendations, where the abuse of infrastructure has been the most key area that was an area of concern in the commission. They did not even entertain that. Yet now we are seeing in Chapter 4, they are assuming that what they put taken from the 2017 regulations as a framework now. And I agree with Prof Quinot in terms of that. How would one be so operational and standardized, so standardized in the act itself? So for me, colleagues, I think we will take that chance again, but we are planning also to make a physical presentation to Parliament in as far as our mandate is concerned. For us, colleagues, I don't know why National Treasury moved out from 16A6 of the PFMA, which then recognized the CIDB in the space, unless if the so-called PPO office is then going to build that capacity and have a construction industry component within the PPO's office, then that's how I would always see this bill or the implementation work. But for me, I'm seeing a serious confusion in the industry that we are going to be faced. Thank you.
Interesting. Thank you, Richard. Prof Geo, any response? Ron was the first one up. I'll ask Helen to come in as well.
Yes. As I said, I kind of oscillate between different views on this bill, and what is better at this point in time. Because the reality is we're faced at the moment with a less than optimal, let's put it that way, procurement regime. I think, the 2022 preferential regulations is, they've certainly made our lives more difficult. Things that I never even contemplated when I looked at them at the first time now emerged during the course of last year. It is an utter mess at the moment, especially at local government level, to know just what can we do, what can't we do. And to me, that is just, I don't know, it is really bad. Whether, opting for less optimal but slightly better position, I don't know. I am somewhat joining Helen in her cynicism, in the sense that my own experience of the parliamentary process over the last 3 months have been, not that I had high expectations, but even disappointed those very low expectations I did have, which really has made me wonder whether trying to craft a proper bill, meaning primary statute, is really, in our reality, a viable approach. Because unfortunately, I've been reading the reports of the committee. Again, unfortunately, it seems to the case that just very few points capture the imagination of the politicians. And then they run with that with very, very little real engagement or understanding of the real technical operational matters that in this group, for example, we would talk about a lot. And I fear that will always be the case, which then makes me wonder, well, should we not then rather push for a really skeleton bill, just a very few handful of provisions, and have a body create detailed regulations where we can, with technical people, sit around the table and have a proper conversation about what would go into those regulations. And that doesn't have to go through a parliamentary process, a public process, but not a parliamentary process. But as I say, I changed my mind on that often. I'm on record in 2014 as having advised the CPO that I think the correct approach to legislative reform is not this one-shot approach. The correct approach is to start with institutional reform. And I think all the comments we've received we've heard now, really confirms that point. And that is, our point of departure is problematic. We've got an institutional problem. The National Treasury, the current officer, the Chief Procurement Officer, this new PPO will not be able to address the issues that our colleagues have now put on the table because of organizational, institutional shortcomings. I made a quick note as people were talking. So Helen reminded us about local content, right? And how important thing to do that. That's not Treasury's job. That's DTI. They're the only people that can do that. But they are marginal, right? They're on the fringes here. Ingrid reminded us of the importance of BE. Where's the BE Commission in this whole thing? Right? They're missing in action. That's their mandate. So where's their voice? How are they going to deal with this trumping thing?
Okay, so I'll see you tomorrow. Tomorrow.
Richard has just reminded us of in the infrastructure construction space, both the CIDB, but also absolutely spot on, public works. Where's public works in all of this? And we can replicate that. I mean, we've had many conversations also with around things like, I mean, Chelsea also made this point about transparency that links directly to the counter-corruption, the whistleblowing. That's a justice matter. Where's that? So I remain convinced that, and then Ron's point, of course, around higher education and research. I remain convinced that what we need as a point of departure is an arm's length regulatory structure that does not form part of any particular government department, so it doesn't have a substantive mandate that it must push. Its job is to ensure that procurement operates across all sectors and all interests. Once we've got that, and that's the only thing we should start with, then that body can start to engage and build appropriate substantive rules that can be fit for purpose in different contexts. I remain convinced it's the only way to go. it's not what we've got. So what do we do? So to respond to Ron's points, strategically, I think we must use every opportunity we've got. The best opportunity at the moment is this very surprising and very welcome opportunity to engage directly with the select committee. I think we must do so. I think it is worthwhile pointing out that Yunus Karim, who's the chair of the select committee, he used to be on the other side, right? He used to run the standing committee. And if you ever engaged with him when he was there, you'll see that he's a straight shooter. He's doesn't take nonsense. He knows what he's talking about. So I've got a lot of hope for a select committee with an appetite to do something. So I think we must use this opportunity. We must go and tell them very loudly that their learned colleagues on the other side messed this up. They cannot afford to do the same. So we need to have proper process. So I think that's a great opportunity. We must all use it. And then, you know, the next step would be to engage with both politicians in Parliament, because there's the possibility that a third of the members of the National Assembly can refer a matter to the Concord for their view. Now, a third is a big number, but still, you know, in the strange politics that we live in at the moment, one might get there. So that might be one way of being quite activist about it and say, look, we're just not convinced of some of these things. And we really don't think we can move forward unless we get some clarity. So, for example, we need to get the question that Helen asked, I think is a critical question for any statute. Unfortunately, Agribusiness half answered it, but also then didn't answer it. So now we're not sure what exactly is the scope, what is the meaning of 2172 when it says there seems to be a discretionary power. Does that also mean that you cannot force organs of state into a particular form of preference? Is that the implication of 2172? I don't know. So it might be useful to get the Concord's view on that. And that may help us then avoid long, protracted uncertainty litigation. So that might be, the president himself has got that power as well, right? So when this is passed by the Assembly, they send it to him. He must apply his mind, and when I say him, of course, it's his whole, the presidency, the whole outfit. They've got serious lawyers and serious people there as well. So that might be another place where one can engage and say, look, we think this is risky. And he may then send it back and say, look, think again. And of course, let's just remind ourselves that if any of this happens, it's game over for this bill, right? Because there's no time. So I think those are the things that I would say at the moment. One should use these opportunities that's there at the moment and try and explore them. And hopefully one can have some input. So and I think that also talks to some of Advocate Luba's around an activist role. Should we try and get this? I think it's meaningful. No, I doubt whether the Solicitor General or the Attorney's Office will entertain a request or an invite from an outside party to give a formal view. I would be very surprised if they will, but of course we can invite them. And then talking about, we are having another gathering, so let me say that immediately. I've just had the funding confirmed. So we will have another 2-day jamboree somewhere in Gauteng, where we will invite the entire community again to get together and let's talk about some of these things. And we're still kind of agenda setting. So please let us know if you've got particular ideas. And the bill, of course, will feature. We will not be doing again what we did last year. I think we must move forward. So we'll see where we are in terms of the bill. If this thing passes and then we go into regulation mode, we will apply our minds there. But I can tell you one big agenda item that we will be engaging with is capacity building. And we want to be quite constructive and proactive. So our plan is to try and develop a national curriculum on procurement for the country, to say, look, this is what we agree across the board. This is what we should have. And to really workshop that with the community of practice, so that on the back of that, one can then start to build a certification accreditation system that will do that. So that will be part of it, but it's 2 days, so we've got more scope. Yeah, and I think then the other comments all really just show us the lack of alignment. There are many substantive issues that's just not aligned. And we cannot go forward on this basis. We cannot just feel our way through it and then discover that, oh dear, we never thought about the fact that now in procurement, people are just ignoring the BE certificates. Oh dear, that's got unanticipated. It's not unanticipated. A lot of this is now anticipated. And I think we must continue to put up the pressure, and not just on the bill itself. I think one shouldn't just put all your eggs in one basket. If one then does not prevail on the bill, one should just shift that pressure to the regulations and say, okay, right, so the bill is perhaps not optimal, but how can we minimize risk in the regulations? And then come with proposals on, okay, so how do we want the regulations made, let's say under chapter 4, the new preferential regulations. How do we want those to talk to the BE scheme so that we get the kind of certainty that both Richard and Ingrid's been talking about? Let's actively frame it. And I think that could be quite useful. Yeah, thanks. I think
Prof,
that's
thanks, Prof. Helen, any comments? Or will you run?
I'll be quick. On the strategic approach, I fully support Prof. I think what I would like to see is literally, as Prof was indicating as well, legislative drafting 101. Let the bill focus on the what and let the how be done by the institutions best fit for it. If it is the DTI, let them do their work. If it's the Public Works, let them do their work. If it is a municipality, let them do their work within their environment. Something I would also like to see is, and I think that is something we miss in this bill, is if you look at the PFMA and the MFMA, when it was promulgated, the message was, we're now going to be outcomes-based focused. We're not going to focus on inputs anymore. But if I look at this bill, I only see inputs. I see no outcomes. And in the end, we're going to pay per hour for consultants without any deliverable because it's not based on the outcome, it's based on the input. And then, Prof, maybe a challenge to you is, I would love someone to do a thesis on what it cost this country, the 2017 regulations, and the amount of time it took one institution to test the constitutionality thereof. Because if we're going to continue with this bill the way it is, we're going to see a similar scenario. And what will it cost this country? And I just don't think we can afford it. But that's my message. Thanks, Shaun.
Thank you, Helen. A question. NHI. Has anyone looked at these two? And isn't this the question maybe to put to Eunice and his team? Because NCOP pushed in NHI through quickly, it would have been a different select committee to finance. Is that possibly the little trumping mechanism we could use at this level? Or am I barking up the wrong tree here, Prof?
No, Shaun, you're absolutely spot on. It's one of these absolutely puzzling lacks of, they're like ships in the night, they in Parliament at the same time. I can see no sign of any conversation between anyone involved in the two processes. Because if you look at the NHI scheme, it boils down to procurement. I mean, all health services, not just public. Remember, under the NHI thing, everything becomes public. So all health services in this country will be run through procurement. All GPs the bulk of their practices will become procurement. Now, how is that going to be run under this bill? Who, how, when? No indication whatsoever. And that's just one mega example. I mean, the other one that I think Ingrid and Richard has also pointed out is that while this thing is happening, we know that there's a mega push for more infrastructure. We all know that is how we're going to get the economy working again. There's a policy now. almost complete silence on, okay, so how are these two things going to work together? Very concerning.
And these are the points that need to be raised. And this is probably the committee that will listen. And we'll have to answer some of these questions. Quick, last comment then from Advocate Nsaluba, Ingrid, and Nicholas, and then we close off for the day. I've got some suggestions for next week.
Thank you very much. I hope you can hear me.
Yes, we can. Quick one.
Thank you. A quick one, Prof. I would not want us to think that regulations would solve the problem. I'll give you one example.
Yeah.
The part that dealing about the section dealing with regulations, it's still incorrectly crafted. I didn't want to get to the detail like the other colleagues. I wanted to stick to the generalities. You've just said procurement is cross-cutting. You are sitting with energy now. There's NHI. There are others. It's cross-cutting. In defense, we call it a support capability. Now, if it's a support capability, when you are writing a regulation, you do, I even said in Parliament, I repeat it, you do what we did with the regulations on military veterans. Because if that particular support or benefit cuts across various organs of state, then the consultation must be done through all of them to make sure that the regulations are sacrosanct. But if you allow the act to go as it is now regarding how regulations are going to be done, you will not be able to correct that in terms of regulations. So my appeal is that we need to spend more time and patience in making sure that the will of what it is that must be done for service delivery happens. And coming to the issue you're speaking about the curriculum, I'm excited about the issue of the curriculum, and I'm hoping that probably we could move faster on the programs development and see how then that gets registered in the proper processes so that even universities are able then to use that. Thank you.
Thank you, Advocate Ingrid, and then Nicholas. Quick one, and then we close off.
Sorry,
Thanks, Ingrid.
Just to answer your question, Prof, 40 billion is anticipated to be put out for tender by SOEs in the next 6 months. And of that, 20 billion is SANRAL in the construction industry in the next 6 months.
Yeah.
And just to Shaun, just respond to that. So, I mean, that's an important figure to bear in mind, and also the intended knock-on effect when we talk about the certainty we need for that money to do what it's meant to do. Because if that money is going to be thrown into a very uncertain, murky world, as we've seen in very recent past, SANRAL tenders being, you know, it's a dangerous position we're entering into. So what we need above all is really a high measure of certainty in that space when we make that kind of investment.
Sorry, just to answer you here, that is our biggest concern, is that this bill allows government to switch on BE and switch it off if it could be in the energy sector and they're wanting to attract overseas contractors to come in and do business. This trumping clause in the procurement bill allows them to turn BE on and off. So there is no certainty at all in our industry in terms of this big infrastructure spend. And we think it's been done deliberately, and no one's picked that up.
Thank you, Nicholas.
Hi, Shaun. Just very quickly, you mentioned there was a mention of the NHI bill in the process there. The one thing that I picked up there that was, in my personal view, completely embarrassing, was that the committee submitted a report to the NCOP, the full plenary, and that report was a one-liner, essentially. It was embarrassing. And I cannot see how the comments that were given to that committee ended up in front of the full NCOP. And so I think we also, you know, as public should be keeping an eye on what this committee actually does when it eventually processes these comments. And I'll just quick quote from Mohale. A reasonable opportunity to participate in legislative affairs must be an opportunity capable of influencing the decision to be taken. It is unreasonable if the content of the public hearing could not possibly affect Parliament's deliberation. if that hearing is not timely advertised, if people are unable to attend the hearing, if submissions are not transmitted or accurately transmitted to the legislature, then the hearing is not capable of affecting Parliament's deliberations. I mean, that quote, I think, should be ringing in everybody's ears. Thank you.
Right. Well done. Thanks, Nicholas. Thank you, Prof. Any thoughts on the way forward? So we've got a whole bunch of people here that have made submissions in the past. We've counted 6 now that we've got online today. They could probably go through and do some work on that. Is it worthwhile having a more detailed, almost clause by clause walk through of some points that people can maybe include in their submissions?
Yeah. I mean, my advice always is not to do just a general long kind of, text narrative. I don't like this bill because it doesn't align to my, view of life or something like that. That's usually not effective.
Doesn't work, yeah.
No, if you look at the deliberations, those things are just completely ignored in the end.
Yeah.
What works is a very, very focused line by line, and then to be quite specific about what the issue is you want to address. To say so this. So let's take the example of what Helen did earlier. Here we've got section, can't remember the numbers, but whatever in chapter 4, and it talks about this term. This term is not defined, so it can be interpreted in various different ways. This is what we propose should happen. That kind of thing is useful. And as I've said at the outset, I think you are more likely to have an impact on the select committee if you frame every single comment from the provincial, local perspective, because that's the thing that will be at the front of their minds. So if you can show them why whatever you are saying is something that they should be worried about, you are more likely to have an impact than not.
Good one, good one. Ron, you've got your hand up. You want to make a suggestion on some next steps?
I want to support the idea of having another session and essentially just hearing from others what the provincial impact will be, because that'll inform everybody's contribution. We all learn from each other, and I think if we all agree with what's said, then all in our individual submissions, we can then replicate that. So it's not just one submission, but they can see that there's a groundswell for it. So maybe the next session we should dedicate for that. But Shaun, I think Prof Geo mentioned one alternative about the presidency. And as a parallel option, I'd like to explore that in more detail. Because, Helen, for example, raised a very key issue, a key unresolved issue on preferential procurement. There's some big issues. So if we wrote to the constitutional courts, in an ideal world, what would be the top 5 key issues that we would like to ask clarification on? And I think there's merit in putting a memorandum together, signed by as many people as possible, to the presidency, stating that there are just fundamental flaws, confusions, needs for clarity, whatever, on some big issues. And then the ball's in the presidential court, as it were. And there again, that would be written from the perspective of the presidency. We've got this increasing nationalization, which contradicts with this local initiative. He's very pro innovation, but this thing hampers that. And so, we just highlight that he's not been given the support he needs as president. So that, maybe we should have a bilateral, on that particular approach. Because I think having a lot of signatures all going up to the presidency and maybe even making an open letter, I think has merit.
Thank you, Ron. Noted. Sanele, and then we'll close off.
Thanks, Shaun. No, mine is just to thank Prof. And I think there is an indication that he's leading the call now with the professionalization. Thank you very much for that. I will be the first student as soon as it gets ready. So, yeah, thank you. No, we've been trying to echo these sentiments and try and find National Treasury to play on the same field that you are in terms of professionalizing procurement. So thank you very much, Prof, for hitting the call. So we'll definitely back you on that.
Thank you. Prof, you've put the closing comments in the chat, and I remember that very clearly, that request for that report. Have you seen it?
I think I just my eye just caught it, and I thought I'll just post it for everyone's benefit there. And to the best of my knowledge, I've not seen something like that. And if you just read those comments, this was the closing comments at the end of the public participation process. So after this, they went into closed session, well, closed in the sense that only them talking, and you'll see if you read those closing remarks that there are a number of assumptions there, which we know, those of us that's been there from day one, are not true, right? Assumptions like National Treasury held workshops and public hearings, which they didn't, right? There was no, we had an opportunity to submit stuff in 2020. We weren't even told what they received or how that was. So that's interesting. I've not seen, and I would love to be corrected. Really, I'm honest here. If anyone else, please share with us. But I've not seen this envisaged report. And you'll see the chair is very clear here. It's not a vague idea. This is what it should say. This is who should do it, and it must go with our report. I've not seen it. I'll be very curious to know whether that's happened or whether this is just something that was said by the chair and then it just disappears again. Anyway, I think some interesting thought and something that we might perhaps want to point out to the select committee.
Yeah. Ask for the report.
Yes.
Right. Thank you, Prof Geo. Thank you, Helen. Thanks everybody for contributing. I've got some ideas. I'm going to be discussing them with Prof Geo and Helen in terms of what we might want to do next week, and see if we could possibly assist you in putting some submissions. But whatever you do, plan on making another submission. Those who've not made submissions, you've got a great opportunity to make a submission. Really do. It's we've got this window of opportunity to have some influence here. We must use it. Thanks everybody. We'll try to get this onto the YouTube channel as soon as we can. All the best, everyone. Thanks. Good week.
Thank you. Bye.
Thanks
so
everyone.
much. Bye-bye.
Everyone, bye-bye.
Thank you very much. Bye.
Thanks, everybody.